Well, thank you. And so, yeah, folks, I can't see your names in the chat or your questions, but Shelley will let me know. And I can't see your faces either, but trust that you're there, and I appreciate you joining. I hope some of you were able to join this morning's training with our wonderful colleague Ariel. I think in some ways this will be sort of a part two. I know he talked about removal proceedings and asylum proceedings in the immigration court here in Atlanta, specifically for pro se asylum seekers. I'll be talking about basically the next step in that process, which is the appellate process that asylum seekers and other folks with forms of immigration relief can seek if their case is denied in the immigration court. And so we'll be going over a little bit of the nuts and bolts of that, but I don't want to take too long on that because ultimately you all can, research and look up a lot of things if you have an appeal when that time comes. But I wanted to give you more of a bigger framework of how the system works, where it fits into our government and our society, and what it really means, and really to show that it's not really a system that's set up to fairly appeal these decisions. It's a system that's set up in many ways a racist system, and a system that is looking for our clients to fail and be denied and be deported. But we have to work within that system to zealously advocate for our clients, and we also I'll also give some ideas of ways to advocate for change to that system as well. And I'm going to start because I think I'm the only speaker in this series actually from our Tahirih office, even though Shelley has hosted all of these trainings. So I'm going to start out with just a little bit of background on who we are as an organization and what brought us to Atlanta. And then I'll move into the appellate process. I'll give some examples of cases that our office has taken on, or our organization has taken on, and then give some ideas of further reading and further resources. So who we are. Tahirih is the largest nonprofit in the U.S. that specifically focuses on survivors of immigrant survivors of gender-based violence. And we have 5 offices now. We are the youngest. We opened in 2018, but the Greater DC office is over 20 years old. It was founded in 1997. Served over 25,000 individuals and their families. And another quite unique thing about our services is our holistic approach. It provides both legal services and social services. Our wonderful social services manager, Eileen, will be speaking on Monday about the social services program. And I encourage you all to learn more about that from her and her other colleagues who will be co-hosting it from, I believe, Gain and Kind. Tahirih has a special 3-pronged approach, and this nice little graphic sort of lays it out for you. But essentially, our DC office has a policy team, and what we do is we take the stories and the individual cases of our direct services teams, and we elevate those to the national level, and that's helps us advocate for policy changes and provide specific examples. So not a lot of organizations do both the policy side and the direct services side, and so that really allows us to share what's really going on the ground, what's really affecting our clients at this policy level. And we also, the third prong is training and education, where we try to go out into both the community and to other agencies and allow them to better understand the issues facing our clients and how even the legal forms of relief that are in place are maybe not working and not serving their interests. And so that is sort of our 3-pronged approach with this long-term goal of ending gender-based violence and providing safety for both our clients and their communities, and ultimately changing the law in their favor. Our office does and Tahirih offices in general, this is just kind of a list of the services that we offer. I know most of you all have been through a number of trainings at this point, so you're probably generally familiar with with a lot of these. Asylum obviously is a big one, and that's what I'll primarily be talking about today. Our appeals at our office tend to be of asylum decisions. And we focus specifically on gender-based asylum. So a lot of our cases involve domestic violence, sexual assault, persecution based on sexual orientation. And our appellate project takes those cases up to the next appellate level. And we do that both through appealing our own cases if we're unsuccessful, but also we've done a lot of community outreach, and now are taking appeals from other attorneys who aren't able to do the appeal, don't have the expertise, or for whatever reason think we may be able to get a better result in the case. We also do T and U visas, which are special visa programs for survivors of human trafficking, as well as for certain crimes, which include domestic violence and sexual assault, but a number of others as well. VAWA is a special visa protection program for survivors of domestic violence whose spouses are LPRs, lawful permanent residents, or U.S. citizens. And that allows them to petition on their own for legal status so that they're not tied to the abuser's status. And finally, SIJS is a special immigrant juvenile status, and that is a program for minors who have been abandoned, abused, or neglected by one or both parents. We primarily, we don't do a lot of those cases because we do have KIND, which specializes in children's cases, and a couple other orgs in the area that handle those, but we do take them on occasionally. So why Atlanta? Why did Tahirih come here? Why did we choose it for our 5th office? And I shouldn't say we. I didn't choose it. I was here already. But we came here for a couple of reasons. One, I think it's a little surprising to most people what a big immigrant community there is in the state of Georgia and in Metro Atlanta especially. It's not a border state. We don't seem all that connected to Latin America, but in fact, we have a very large immigrant community, approximately 10%. I've heard that in part is because of the Olympics being hosted here many years ago, brought in so many workers to build all the event spaces, and many of them stayed and set down roots. And now many asylum seekers and people who cross at the border have family ties here in Atlanta, and it draws them to here, and they end up here and in need of legal services. And as you've gotten to know from these past few trainings, there are a number of wonderful other offices in our community assisting with immigrants in need of legal services, but even with them and us, we still have to turn people away. So the need is still not met, even now that we're here. And the other reason we came is because Atlanta is a uniquely unjust place to be an asylum seeker in the U.S. I think Ariel probably touched on this morning if you joined his training, but the denial rate here is higher than almost anywhere else in the country. I think we're about on par with El Paso, which has one of the highest rates as well. In a lot of places, you've got a 50-50 shot of getting asylum. Here you have between 2 and 5%, depending on the statistics. It's incredibly low. And these are federal laws. These are laws that really should look the same around the country. And that just shows the bias of the judges here and the attitudes of the judges towards these people seeking safety in our country. This is also a very large immigration court. We have 3 large detention centers in Georgia. We have a whole courthouse just for detained cases, a whole courthouse just for non-detained cases. They're actually hiring new judges right as of now. I think 6 new judges, some of which have come on the bench, some not yet. And then there's a separate court at Stewart Detention Center for the people at the detainees specifically at that detention center. And then not only why did we come here, but why did we decide to have an appellate project? So, I think the last slide explains it quite a bit. We realized that we were going to lose a lot of cases here at the Atlanta Immigration Court, that it was inevitable, and that we had to really focus on appealing those decisions and doing so strategically, and doing so to both zealously advocate for individual clients, but in the hopes of changing the law, of improving the law, and making that that denial rate go down, that we would force these judges to decide these cases differently. And, we're only a couple years in, so I can't say there's been a dramatic change yet, but we have had successful appeals and we feel like we're pushing the law in the right direction. We also have a few strategies for how we're going to do this, because obviously myself alone doing appeals in our little office isn't going to move the needle that far. So we work closely with pro bono attorneys at some of the large law firms, both here and nationally. Since Tahiri is a national organization, we have a lot of ties to different law firms throughout the country. We've also provided trainings to other attorneys in the community who already are practitioners of immigration law, but may not have a specialty in appeals, may not really know how to present their appeal in a way that's going to be most persuasive, and may not know the issues to raise exactly. So assisting them, trying to help keep everyone more up on the law, which has been changing so quickly. It's very difficult to stay on top of it. So those are some other strategies. We're also doing community outreach and pro se assistance. We're working with actually the pro se workshops to develop appellate materials that will help them hopefully better be able to advocate for themselves, or at least know that there is an appellate project an appellate process that they can pursue. At the end of an immigration court proceeding where you were denied, you do get, the judge does give you a little warning that you have 30 days to appeal, but that's it. And you have to figure out the rest of the process on your own or hire an attorney to do so. So community education is very important to helping people understand their rights and pursue them. And then our other, as I'll talk about later, we also can raise cases and bring cases to the 11th Circuit Court of Appeal, which is the federal appeals court in Georgia. I'll talk about more a little bit further on. And what I'll talk about more further on is that the asylum system as a whole has been under attack in this administration, and we're really intentionally trying to take cases up on appeal to push back to ensure that this right still remains accessible to asylum seekers and people seeking protection in the United States. So this image is something I just pulled offline. This is from EOIR, which is the Executive Office of Immigration Review, and that is a branch of the Department of Justice. So I just want to pause here and make sure that everyone kind of understands the framework that we're working in here. We are not working in regular courts. We're working in the immigration court. And the immigration court is not an Article I court. It's not a state court. It's part of the federal government, and specifically the Department of Justice. And that gives the Attorney General a lot of power over it, and we'll talk about that more later. But just in case, I'm not sure if any of your prior trainings have really covered just how the process works. And I wanted to just have this flow chart here to kind of be a little bit of a guide to kind of where what we're talking about today fits in. I'm going to try to use this pen function, see if this works. So here, we are mostly, oh dear, sorry. We're mostly going to be talking about, nope, the pen's not working. Sorry, everyone. We're mostly going to be talking about the BIA, which is here on the right. That's going to be where appeals go after a decision of the immigration judge. But I want to back up just for a couple of minutes and walk through how that happens. How do you get there? So it says here, DHS initiates an action, and you get a notice to appear in court. That's often called an NTA. You'll probably hear that term if you're working in any kind of immigration office this summer. Someone can get an NTA in a number of ways. They can be apprehended at the border. They can enter through a port of entry and claim asylum and then be detained. They can be sitting at home and get one in the mail. They can get arrested for driving without a license and turned over to ICE and get an NTA. This is sort of like you being served with your a subpoena to come to immigration court is sort of how the equivalent would be in other courts. Once you've got that, you are in removal proceedings, and that is not a good place to be. especially right now. The next thing you would do is you would get a master calendar hearing before an immigration judge. If you offer no basis for relief, you don't say, I'm fearful of return to my country, you don't have a lawyer, you don't have any other basis for legal status in this country, you could be ordered removed at that very first short hearing. Or you could choose voluntary departure, but you would be ordered removed one way or another right there. If you claim fear, if you ask for asylum, you will get this merits hearing. It's a little bit like a mini trial before the immigration judge, and you will be able to testify, present your case, present other witnesses. If you have lawyers, you'll have briefs and declarations and other documents prepared in support of your case. Next, the judge will issue a decision. If you are denied, you are ordered removed. However, you have 30 days to appeal, and that's where we're headed. We're going to spend most of our time there talking about that appeal to the BIA. After that appeal is denied, you'll see you can appeal to the federal court, and I'll also just touch on that a little bit so you're aware that there is some federal review out there eventually, though not very much of it, quite frankly. So now what is this Board of Immigration Appeals? As I've mentioned already, it is not an independent court. It is part of the DOJ. It sits in Falls Church, Virginia, in a very nondescript building that I've actually driven by. They never grant oral argument. You can go in and, I guess, file documents in person. I've always done it by mail because I'm here in Atlanta. But other than that, it's basically this nameless building where you never see a real judge and never have really an opportunity to advocate other than on paper and by mailing things. There's 23 board members currently. The numbers shift a bit. They just hired quite a few more. And they have a team of staff attorneys who have very, very high caseloads and who review these cases very quickly with an eye towards really disposing of them as quickly as possible. I did a training similar to this with someone who had been a staff attorney at the BIA, and she painted a pretty grim picture of how little review each case is given, how high volume their caseloads are, and that they're actually rewarded for the speed at which and the number of cases they dispose of, not on like the reasoning of their decisions or their upholding of the law. So they have kind of a built-in incentive to just crank these cases out. And as I'll talk about more later, whatever decision does come out of this board, it's extremely high deference in federal court. So even though there is that next level of appellate review, you're going to be very much bound to what was decided in the BIA unless they really mess up, or you can show that they really mess up. So you have to preserve those issues, and hopefully the federal courts agree with you. Lost my mouse. I also have to share some really depressing new rules at the BIA as of 2019-2020. Things were already, as I said, they're quite dismissive. It's quite difficult to be successful there. But now there's these sweeping new rules for summary affirmance, which is basically a denial without reasoning. And a single judge can make that decision. There's more authority now for them to just have one judge make that decision as opposed to a 3-judge panel, which used to be the case. They're now enacting stricter kind of quota time limits for deciding cases, and that if the judges don't do so in time, the EOIR director, who happens to be a very anti-immigration person named James McHenry currently, can decide the cases for them. I hope you all can appreciate that this is not how a real normal court would function, or appeals court in this country, and that these are the kind of rules that can be put in place because it's an administrative body and not a real court of law. They now are denying almost all fee waivers, which means if you're unable to pay the $110 fee, and they are still granting them for detained folks, but for non-detained, if you can't pay that $110 fee, you may be out of luck in terms of filing your appeal. And there's a proposed rule to change that fee to around $1,000, so almost 10 times what it is now. That kind of money is just really an insurmountable barrier to many, many of our clients. And even to us as far as how many appeals our office could take on, unless we have, a pro bono firm that's willing to pay those fees on our behalf and on our clients' behalf. Another really depressing development in the last few months has been that they have promoted multiple immigration judges who are notorious in this country for having the highest denial rates for asylum to the BIA. This is a pretty clear demonstration of this administration's intentionality to deny more people asylum and to reward judges who deny people asylum. And then this was in the news just in the last week or so. Apparently there has also been basically bribes, an offer of a payoff to longstanding BIA members who may have, actually have expertise in the law and may not be so anti-asylum seeker and may have more impartiality to retire early. And apparently it's also tied to a pay cut if they decide to stay on longer. So some pretty extreme tactics to stack the court with people who support this administration's agenda. I don't know how many folks have heard of this, but there's a method, and I had never heard of this before I came to immigration law either, called agency certification. This is something you may have heard about a little bit here and there, that the Attorney General has actually certified a number of immigration cases to himself. What that means is he can take, I thought this quote at the top of this slide really explained it better than I could. Certification allows a political appointee who heads an enforcement agency and is subject to the policy agenda of the administration he or she serves absolute authority to overrule or completely rewrite the decisions of an ostensibly neutral and independent tribunal comprised of judges possessing greater subject matter expertise. And that is exactly what has been happening. Jeff Sessions, William Barr have been taking cases decided by the BIA and just trashing those decisions and rewriting them themselves. And all of those decisions are very, very tactical and strategic to limit access to asylum and other forms of immigration relief. I've just named a few here, but there's actually been many more. These are some that affect our clients most. Matter of Castro Tomb, which keeps people from being able to close their removal proceedings while they pursue another form of relief, maybe adjustment to get a green card or something like that. Matter of AB is the most impactful for TAHIRIH'S work because it really sought to limit domestic violence as a basis for asylum, as well as gang violence. And also Matter of LEA, which is another one that sought to limit a ground for asylum based on family membership. So if you're persecuted because a cartel has targeted your entire family and maybe has killed several of them already, that family membership is no longer an independent ground. Now, all of these cases, we are not as pessimistic as that may sound. We think that there's lots of dicta, that there's lots of loopholes, that they didn't change the laws dramatically as they attempted to. And some circuit courts have agreed with us on those, but there's a lot of uncertainty and gray area in the law right now. And certainly for the judges who already were against us and against our clients, these cases have given them a lot of power to rule against them, and to do so with the blessing of the Attorney General. So yeah, this is, I hope I haven't bummed everyone out too much yet. I also want to just bring up, I think, a pretty, what I think a lot of you may have recognized already from these policies and from this administration's agenda. But these policies seem very, very clearly targeted at a racist and xenophobic agenda of othering people from other countries and other ethnicities. And although, some of these changes have been very technical, like administrative closure, what is that? They're all aimed at the same thing. And I actually got to travel to the border quite recently, and believe me, everyone who's there is from Latin America, and the few that aren't are from Africa. So these are brown and black people who are being systematically denied asylum through a very unjust system The Northern Triangle countries are where most people are coming from right now, which is Guatemala, Guatemala, El Salvador, and Honduras. Those are countries with highest femicide rates, some of the highest femicide rates in the country, some of the highest gang violence rates in the country. It's no coincidence that they're seeking protection and that they're fleeing these countries, and there's also no coincidence that our administration is trying to keep them out. We've also seen asylum seekers coming in from Cameroon, from Kenya, from Congo, seeking protection from political unrest and violence in those countries as well. So I just want to be very clear that these policies aren't part of a, securing our borders or necessarily or any kind of real theory of justice. They're very much about excluding certain groups, and that's been what we've seen now with policy change after policy change. Just today, some new rules came down. They're proposed rules right now, but would actually are seeking to essentially codify some of those bad decisions I just mentioned, so that they're even more embedded in our laws. TAHIRIH'S policy team has been expecting them and is ready to fight them. But we just, time and time again, we've seen these really unfair policies come down. And so at this point, you might be wondering, like, why do I do this job? Why do we even appeal things to the BIA? This system is so broken. This is so terrible. And there's certainly, times where us as advocates question those kinds of things. But ultimately, we have to zealously advocate for our clients. We have to fight the system both from within it and without. And we do have clients who are successful on appeal, and we do think that we can still push the law, even if it's a very uphill battle. So now I'm going to turn to talking a little bit about the BIA filing of an appeal itself, since this is an intro to immigration appeals. I know that you are all smart and can look things up, and if you ever had an appeal or if you get handed one tomorrow, you can find out a lot of things. You could research it and figure out what to do, but I just want to give you some very broad ideas of what it would look like if your supervisor hands you an appeal tomorrow. First, what do you file? So this isn't so different from actually any court of appeal. You file a notice of appeal. You file a notice of appearance as that person's attorney, and you pay the filing fee, or you ask for a fee waiver. What is different is, like so many things in immigration law, is because they have a form for it. So EOIR has a form for the notice of appeal. It has a form for the notice of appearance. And then when do you file that? So this is also really important. This is probably the most important thing about filing an appeal is you have 30 days from whenever the IJ immigration judge made the decision. That's going to be either 30 days from the oral decision, which they may make on the record at the hearing itself, or they may not decide the same day as the hearing and send a decision in the mail within a few weeks or months after that hearing. Whatever date is on that decision, that is the date your appeal is due in 30 days thereafter. And if it was oral and during the court proceeding, it's 30 days from whenever that court proceeding was. And it goes to that office way off in Falls Church, Virginia, that we never see anyone. You mail it there, and there's no mailbox rule. I hope you learned the mailbox rule in law school at some point, but basically it means it doesn't matter when you mailed it, it matters when it's received. And there's actual BIA case law about things being lost by FedEx or something completely out of the person's control and an appeal not arriving timely, and that appeal is still rejected. So I can't emphasize enough that you need to get that appeal there within 30 days or you will lose that right. This image of a mailbox on fire is there to be a reminder of that. So you did it. You did the E26 and the E27, and you did it on time, and you get this bright pink receipt in the mail that you filed your appeal. What do you do next? You actually wait for a very indeterminate amount of time for a briefing schedule and a transcript of the hearing that you are going to be appealing. I found this very strange when I transitioned from criminal defense to immigration law. There's no court reporter in immigration proceedings. They just record it on audio. And at some point, somewhere in the future, someone transcribes that recording into a transcript that you will get at the same time you get your briefing schedule. Non-detained cases in the BIA are taking over a year, almost 2, to get a briefing schedule. So I have cases where the hearing took place, I have a case that the hearing took place in August of 2018. I don't have a transcript, I don't have a briefing schedule, and I won't get a transcript until I get that briefing schedule. So, we try to take really copious notes during the hearing, but we have no record upon which to prepare the brief or to review until we get that transcript. There is a process for requesting the audio, but it's as an appellate attorney, you know that the transcript and the record is just kind of your bread and butter. That's what you need to have to raise your issues for appeal. And that's an added challenge in immigration proceedings. Detained cases, the briefing schedules do come faster. Those are prioritized, but we're seeing cases take months instead of weeks and also be delayed there. COVID, we've seen almost no action in a single one of our appeals, which is, even though the court has officially remained open. So now we really don't know what's going on or how long further cases will be delayed. When you do get a briefing schedule, you have 21 days to write the brief. You used to be able to request an additional 21. That's another change that they're now disfavoring that. As you can imagine, we rely heavily on pro bonos to partner with us on these cases and suggesting to a pro bono, hey, do you want to take an appeal? You might get a briefing schedule in a year or 2, and whenever you do, no matter what's going on with your own caseload or your own deadlines or your own vacations, you will probably only have 21 days to write that brief. So that is a challenge for us. It's a challenge for getting pro bonos on the cases, and this is from a body that purports to encourage pro bono representation of immigrants, but they're not making it easy. In terms of writing the brief itself, I encourage you to get to know the practice manual, to get to know the law. The law is the precedent decisions of the BIA, that their published decisions, and then the circuit court law of whatever circuit you are sitting in as wherever that case was decided. So here in Atlanta Immigration Court, that's the 11th Circuit Court of Appeal. If that case was decided in San Francisco, it would be the 9th Circuit. And conversely, only other circuit law is only persuasive. So you might find a wonderful decision in the 9th Circuit that you want to apply to the case you're researching here. That's still persuasive, but it's not binding. And so this is my last kind of nuts and bolts about how the appellate project really functions, not the appellate project, the appellate process. What happens after your BIA decision if it's denied? You do have another remedy. You can now appeal to the circuit court. Again, the circuit court here is the 11th Circuit, and you would file something called a petition for review. That is the mechanism for an agency appeal. The BIA is part of the agency of the Department of Justice. However, such decisions are subject to very high deference. If you've taken admin law, then you know about Chevron deference to the agency. And so that's another hurdle where the BIA's decision will be deferred to unless you can show a very high level of error. I also just wanted to flag, just to avoid confusion, that this process is specifically for individual cases appealing their asylum decisions or other types of relief. In immigration court, you may have seen, the ACLU or SPLC filing impact litigation on immigration rights issues that they file in district court that are raising constitutional issues, that are habeas corpus issues, that are APA issues, and so those are different, and those can be original lawsuits, original actions in the district court, and then appealed to the circuit. So this is a special mechanism just for the cases that go through immigration court and then on to the circuit court. So now I'd like to have some good news, some positives, and talk about a couple cases that our organization has been involved in, which had good outcomes on appeal and give us hope for doing this appellate work. So way back in 1996, this is actually before our organization was founded. Our founder, Lily Miller Monroe, was a law student at American in DC, and she, as an intern, represented in immigration court this woman, FAUZIYA Kasinga, who was a woman from Togo who fled as a teenager just before she was going to be circumcised as part of her tribe's female genital mutilation practice. She was then put in detention. At the time, she was actually held in a federal prison with criminal detainees and in really, really deplorable conditions. They went to immigration court, they had their individual hearing, and the judge denied the case. During the pendency of the appeal, the New York Times found out about this case and went and interviewed her, FAUZIYA, in detention, and then it became kind of a news story. And we've heard rumor that actually the BIA case was on the denial pile, and that after it got this media publicity, it got put back on the consideration pile and actually got oral argument, which, as I mentioned, almost never happens in the BIA. It was argued by Karen Musalo, who now runs the Center for Gender Refugee, ERS, Center for Gender and Refugee Studies in California. And it became a landmark decision. As you can see here, this is the site for it, that identified and recognized for the first time that gender could be a ground for asylum, that this persecution and this future fear that FAUZIYA had was based on her gender as a woman. And then going back to this last slide, together with FAUZIYA, our founder wrote this memoir of the experience, both of her experience in Togo and of the case, the proceedings in the case. And the proceeds from that book are actually what was the seed funding for Tahirih Justice Center, which then opened in 1997. Now, a much more recent case and a much more one more personal to me. This was my client, VILMA Carrillo. This case was we actually got it in late 2018, but the result was in 2019. This is Vilma and her daughter Yevsvi. They fled Guatemala due to severe domestic violence, and they came to the border in May 2018 when Jeff Sessions had just begun the zero tolerance policy. And they were immediately separated. Vilma was moved into federal proceedings and prosecuted for illegal entry. Yevsvi, because she was a U.S. citizen, and this is what made the case very unusual, was put into foster care. It turned out that Vilma had been a migrant farm worker years earlier, had come from Guatemala and worked in the U.S., had Yevsvi in the U.S., and ended up going back to Guatemala for a number of years. So instead of being able to take advantage of the class action that the ACLU filed, which allowed many families to be reunited, instead they were still separated for many months longer, even after we got involved in the case and advocated extensively. Meanwhile, she actually was transferred to another detention facility in July of 2018, while the ACLU litigation was taking place, because at first ICE thought that she was a class member and actually flew her to a different facility to be reunited with her daughter. Then they looked closer, saw that Yevsvi was a U.S. citizen and not covered by the class, and instead flew her back to Irwin Detention Center here in Georgia, where we represented her. During the time that she was away, she missed her individual hearing on her asylum case. The judge rescheduled it without giving her notice and had her come in basically as soon as she got back from this botched trip to reunite with her daughter. During that time, the government had taken her backpack as a security measure because of the transfer. I guess they hold some of their possessions for a period of time or inspect them before they're returned at the next detention facility. In that backpack was all of VILMA's documents showing and proving the severity of her domestic violence, statements and support from folks in Guatemala who were supporting her case. She also speaks a rare language called Mam, which is a dialect, a Mayan dialect. So she did not have appropriate interpretation, and she did not have her supporting documentation. We appealed that case to the BIA, and in a strange coincidence, this case also got the attention of the New York Times, and there was an article written about her during the pendency of the appeal. Strangely enough, not long before their brief was due, DHS contacted us and let us know that they would not oppose a remand for a new hearing in her case, which eventually we then filed an unopposed motion, and eventually we did get a positive decision from the BIA acknowledging that she did not have access to these documents and to proper interpretation, and remanding her case for a new hearing. It's funny to show these to you because I actually have a lot of misgivings about using media in our cases and for our clients. I don't think it's always the best strategy. At the same time, as these two cases show, that outside pressure of shaming these courts into doing the right thing seems to make the difference sometimes, and so we have to acknowledge that as well. This is just as Yipsvi's story, and just that ultimately, after we filed a different federal habeas action, she was released from detention and reunited with her daughter. They spent over 240 days, over 8 months apart. And so, wrapping up here, I just want to let you know how we're continuing to fight La Lucha Sigue. We have several BIA appeals currently pending in our office that we think have a lot of merit and that we're very excited about. It includes Shelley and I are co-counseling a case of a gay Cuban man who was persecuted on behalf of his sexual orientation. This is an adorable picture of him when we were able to get him released from detention just a few weeks ago, reunited with his now husband in Missouri. As you can see, even though after over a year of detention, we were still feeling patriotic with those balloons. We have an indigenous woman who survived the Guatemalan Civil War, who lived in this country peacefully for literally decades, and has 12 U.S. citizen grandchildren, who was picked up at a routine ICE check-in in 2018 and thrown back into removal proceedings. Her asylum case was denied. There were, again, many errors within the hearing itself. That case we've actually already taken up to the 11th Circuit and gotten a remand, so now we're back before the BIA. And we just recently took on the case of a Kenyan woman who has a claim based on female genital mutilation as well. And that was a case that a colleague of ours from the community referred to us because of our expertise in that field. Lastly, we just recently in the 11th Circuit filed an amicus brief on behalf of 102 law professors, all of whom were advocating for one of the new rules in a matter of AB not to be followed in the 11th Circuit. So again, we're just continuing to fight for our clients and push back on these changes in the law that we believe are wrong. Lastly, the last two slides are just other resources and other reading if you're interested in appeals, if you're interested just in this bigger process of how the immigration court system works. Tahiri has this e-library and pro bono network that you can join. And specifically on July 15th, if you're interested in these issues, we have a webinar again on appeals where I'll be speaking with the former chief board member of the BIA who was sort of forced into retirement not too long ago and is very critical of the direction it's now going. There's monthly webinars that have like updates on the latest in immigration law and other topics. And then within that library, there's also many recorded trainings, sample pleadings, things like that are worth a look. So if you go on our website and go to join the Pro Bono Network, you will have access to all of that. Here's some practice guides. They're all available online, and they all expand on what we've talked about today. I didn't go into a whole lot of detail about the nuts and bolts and strategies that you would use in filing a BIA appeal, and this is a lot more information. I'll just flag that last one by the Florence Project if any of y'all are out in the community. This website has a lot of Spanish language documents, including one on appealing a case. If folks who are not English speakers needed more information, that is a great resource. And to email me, literally my job is to answer questions and help people better understand the appellate process and appellate issues. So feel free to reach out if you have questions or interest in this area. And this last slide, I just wanted to give you some food for thought for further thinking on the bigger picture issues of this unjust system. This report by SPLC highlights how the immigration courts have basically been corrupted and just become a tool of the Attorney General's whims, and why they should be Article I courts, true federal courts like we have for many other things in this country. This is a really interesting article about how the deference we give asylum cases is wrong and shouldn't be given in federal court. And then a couple blogs I like, both by one by a former BIA judge and one by a former immigration judge, with just really good insights into what's going on with immigration law right now. I'm going to click out of this. I can.
Yeah, it looks like we
have
a couple questions. So,
okay,
and I encourage folks to go off mute so that we can have a conversation as well. So Jeff and Matt, I'll give you a couple. Jeff, do you want to come off mute and ask your question? I can read it out.
Sure. So so you were talking about just those horrific changes that are coming down the pike, and I mean, this is from someone who has been in law school for 1 year, but in my constitutional law class, we talked about there's a case where they held that like excessive court fees are unconstitutional in like certain types of cases. So I was wondering if that might be like a way to challenge that new regulation that would like tend.
Yes.
Yeah.
I expected to have those challenges along those lines. There's this kind of exhausting cycle that we've been going through now for a couple years of these new terrible proposed rules and regulations coming out. Some are subject to notice and comment depending on if they're put in the Federal Register and this whole administrative law process. And then some are litigated right away, some are litigated after notice and comment, but there's been this kind of cycle of having to challenge and take things to federal court again and again. Our national litigation team does some of that, and we've also served as plaintiffs in a number of cases because of we have standing as having clients who are impacted by some of these new policies. So something I didn't get into, and I don't know if any of your trainings is covered, but there's a policy that allowed the government to send asylum seekers back to Mexico to await their hearings. There's about 60,000 people still and right now the border is closed, so those hearings have now been even delayed further. And that is something that's now likely going to go to the Supreme Court. There was a decision in the Ninth Circuit that's being is on cert to the Supreme Court. And we are a plaintiff in that case and a few others as well. But yes, Jeff, just generally, I expect a constitutional challenge to that new rule and to many more that have been coming out, including ones that came out today. And Matt, let's see your question. So I would ask your supervisors if they have sort of questions. If you have an interest in appellate law, I would certainly alert your supervisors to that and ask and see if they have research projects that could bring you more opportunities to learn about that area of law. In particular, I was just telling one of our interns this, who was doing some research for me. Make sure you look in the administrative law section of Westlaw or Lexis, whichever one you use, and look for this database called BIA precedent decisions. Because if you do searches without that, even if they're very specific to immigration law, you're not going to get those decisions. So if you're interested in how the law stands in the BIA, I would take a look at those and seek out projects that require you to read further on those. I would also join those blogs or check in on those blogs that I posted, because I've learned a lot from them, and to have former judges who worked in the system kind of critiquing the changes and the new cases as they come out is a really great way to learn and get an inside perspective on what those changes mean. And yeah, feel free to email me. There's also lots of practice advisors. One thing I like a lot about immigration law in general is there's a lot of organizations that do all these really helpful practice advisories when there's new changes and new decisions, to advise practitioners on how to litigate it accordingly and to represent their clients accordingly. So I would look at ILRC, Clinic, AIC, American Immigration Council, and just many of them are free and just available online, and they cover a lot of topics, and usually within a month or two of any new big decision like these AG decisions, you'll find a number of practice advisories sort of explaining them and letting you know like what the next steps are for cases. Yeah, I'm happy to share this PowerPoint with you all, and I know there's some links in there that you would probably like to have access to, that I went through very quickly. So yeah, I can circulate it to the folks. Do we have everyone's email who joined today, Shelley?
We don't, because there's no like RSVP function, but I think Maria, feel free to email me or Lynn, and we can get it to you. I'll type in my email address. So feel free to email us. I know folks have been emailing me about different PowerPoint presentations, and this has been recorded. So I'm hoping we'll have the whole series up online in the next week or so. Was there any last questions for Lynn?
Minutes, folks.
All right, well, Lynn, I know I really appreciated hearing your presentation as a newer member of our office in Atlanta. And thank you, everyone, for taking the time to join us today. We have two great presentations set up for tomorrow. The first is at 11 with Jenny Hernandez talking about an intro to crimmigration. She works with the Public Defender's Office here in Atlanta. And then at 2 p.m., we have Amy Hauer from Catholic Charities in Atlanta speaking about the public charge rule and family petitions. So those are two great presentations tomorrow. And then Monday is our final presentation in this series with the social services managers of Tahirih, Gain, and Kind. And so for those of you that are interested in some of the non-legal but as critical work of these organizations in providing support to the immigrant community, from food security to housing to all of that, please join us on Monday as well.